Hello everyone and welcome. Make a cup of your favorite drink and get comfortable because this is a wonderful time for new stories from Yellowcat. Send your own stories in the comments below and maybe they'll be in our new video. Lawyers, what's the most obscure law that you've actually used in a case? A law professor of mine was representing someone who owned a goose and was being sued by a neighbor because the deed said no geese. When the deed was written, the singular and plural weren't interchangeable. Professor said deed only said no multiple geese and one goose was okay. Judge agreed. Not a lawyer, but one time I had to sue a landlord who made up some pretend reasons to keep my security deposit. I spent a Saturday in the law library at the local university and found a law that would let me win my lawsuit and claim triple damages. The landlord read my lawsuit and offered to give me my deposit back plus $500. Sweet. One I heard from a criminal defense attorney in law school. His client is driving down a country road at night without any lights on. A police officer is parked off the side of the road and, seeing the man drive by, pulls out behind him to follow him, but also doesn't turn on their headlights. Eventually, they pull the man over and find that he has a lot of cocaine in the cab of his trunk. Charges are brought for possession with intent to distribute. They go to court and the attorney cites the fact that, under the relevant state law, it is not legally required to have your headlights on at night unless there is another vehicle visible within 500 feet of your vehicle. Because the police officer was also driving without headlights, the man had no reason to see them and therefore he was legally allowed to drive without his headlights on. Because of this, there was no reason to have pulled the man over. Thus, the discovery of the cocaine was fruit of the poisonous tree, i.e., any evidence that is discovered improperly must also be excluded. Case dismissed. I routinely cite a 1921 case regarding a forged railroad ticket when I'm trying to argue the best evidence rule of an original that's later been marked up with pen or has some notes on it. The case says that if something is printed out containing all the elements of what it's trying to do, then any handwriting on it is evidence that it's been altered, and the alterations must be shown to be lawful by whomever seeks to enter the item into evidence. Very good to use to keep things out of evidence. I didn't, but worked in an insurance litigation firm where a guy used an 1800s maritime law to defend a case that occurred on a boat on Lake Michigan. He wanted to get it out of state court and into federal court where civil verdicts usually have less value in our area. That was neat. My maritime law professor was a glorious a-hole and I'll never forget this story he told. For this, you need to know that below the mean high tide line on a beach is public access. My professor, in his younger days, had just finished the bar exam. He went to the beach. The beach was super overcrowded. Just a short walk down the shoreline was a private beach club. This beach and beach club were right next to my college, so I've been there and seen both. The beach at the private beach club was wide open and much less crowded. So he walked down the shoreline and parked his chair somewhere below the mean high tide line. A few people from the beach club tried to get him to leave since he wasn't a member, but because he was in the public access section of the beach, legally, they couldn't do anything. A client of mine was writing a scathing review of the Australian court system, which he intended to publish in a book. When advising him regarding defamation, etc., I ended up dredging up an old Australian law of scandalizing the courts, whereby a person commits an offense if they incite disenchantment or distrust to the extent that it undermines public confidence in the judicial system. I don't know if this would be interesting to anyone else, but I drafted an MSJ last year where an insured inland marine trucking company had mistakenly delivered a filled cargo container back to port instead of the client, and it was shipped back to China where it was held by customs and the cargo was eventually destroyed. The insured's policy did not cover mishandling, misdelivery, or misplaced cargo, but provided coverage for all non-excluded losses. They tried to argue that in misdelivering the cargo, they had lost it, and thus it fell under the policy as a non-excluded loss. It only took them a week or so to locate the cargo on its way back to China, so it was never lost, but they still tried to claim that a loss in an insurance contract included anything lost. Dumb as S argument, but the partner took out my entire section addressing the definition of loss, as in to lose, and loss in an insurance context as the monetary value of insured property, and we lost the MSJ. I'm thankfully no longer in commercial property insurance defense, but that one really annoyed me because it was such an obvious mischaracterization of the contractual language and such a stupid move by the partner. I had to give advice to a public entity about the US flag code. An employee had raised a grievance that the way the flag was hung in a particular room violated the code. Technically, the employee was right. The question was what kind of remedy was enforceable under the flag code for a violation. The answer? None. Petty, upset employee got no satisfaction. Obligatory not a lawyer, but I work at a defense lawyer's office in Germany. One of our lawyers managed to get our client off a speeding ticket by finding out whether or not you needed some sort of specific certificate to be allowed to operate the radar speeding gun. He found out there indeed was some obscure certification of many that is needed and is supposed to be renewed every 2 years or so. The officers who wrote the speeding ticket hadn't renewed theirs in a while. Apparently nobody did though. Nobody even really knew about that specific certificate. He won the case. The judge agreed they shouldn't have been operating the radar gun without the certification, even though the dude really was speeding. California sales tax case. Client has to post amount of disputed tax and then ask for the money back before getting an opportunity to sue to get money. There are also interest and penalties. If you do not send a letter asking for the state to not pursue, state can still go after client even though case is pending. On the letter to request the state not pursue, at the top must be written in red ink specific words or the state can ignore the letter per the regulation. This case has been going on since 2006 and haven't been able to file a case yet in court. Also, state never actually has to respond to the request or refund. Not a law per se, but a couple times when the other attorney has really peed me off, and once with a close friend who I feel like messing with a little, I've responded to an essentially unreasonable request, or in the case of my buddy, an eminently reasonable request, by referring them to the reply given in the case of Arkell versus Pressdram. No one ever knows what it means until they Google it. Case is below. Reading to the bottom is worth it. Arkell vs. Pressdram, 1971, unreported solicitor, Goodman, Derrick & Co. We act for Mr. Arkell, who is retail credit manager of Granada TV Rental Ltd. His attention has been drawn to an article appearing in the issue of Private Eye dated 9th April 1971 on page 4. The statements made about Mr. Arkell are entirely untrue and clearly highly defamatory. We are therefore instructed to require from you immediately your proposals for dealing with the matter. Mr. Arkell's first concern is that there should be a full retraction at the earliest possible date in Private Eye, and he will also want his costs paid. His attitude to damages will be governed by the nature of your reply. Private Eye. We acknowledge your letter of 29th April referring to Mr. J. Arkell. We note that Mr. Arkell's attitude to damages will be governed by the nature of our reply and would therefore be grateful if you would inform us what his attitude to damages would be were he to learn that the nature of our reply is as follows. F off. No further reply. I do remember hearing a story where this guy in Michigan was arrested for underage drinking, but was only a couple of months away from turning 21. He went to court and pulled out an abortion law for Michigan stating that life begins at conception. So when he asked the judge if this law was still valid, which it was, he then stated that since that was the case, He was technically over 21 years of age and legal to drink. The case was dismissed, and when the prosecutor made a stink about it, the guy said, "Hey, it's your rules." When I was in college, a girl who worked at an expensive law firm told me this, and I always wondered if it was true. She said that when Oklahoma passed a new drunk driving law, that they specifically mentioned the breathalyzer machine that the cops had to use, and since it was a new one, most places didn't have it. So if you got a DUI and they didn't use that machine or even owned old ones, you could get it dismissed by saying they weren't compliant with the law and used or could have used the old ones. She said they had gotten cases dismissed using that argument. I'm no lawyer, but there's a case that took place in the UK court. Her Majesty's Revenue and Customs, HMRC, versus McVitie's. McVitie's make a biscuit called Jaffa Cakes, and HMRC argues that they were a biscuit and subject to taxation. McVitie's argued that they were in fact a cake, and cakes aren't subject to taxation. McVitie's made a bigger version of a Jaffa Cake, cake size I guess, and argued that cakes go hard and biscuits go soft. The Jaffa Cake went hard, and McVitie's won the case. When I was 13, I was arrested in Portland for spitting. Apparently, somehow in their old A law book, spitting on the bricks was against the law, and they went with it. Handcuffed, thrown in a car with lights and sirens, I was booked at the station. I could hear my mom screaming at everyone she talked to, armed or not, about how effing stupid they were. It was one of the only times I felt like my mom had my back. They dropped the case when she started offering interviews to the local news station, but I still hold on to my citation for a good laugh. This was 19 years ago for reference. It's obscure case law, not a statute. A coworker of mine used a court decision from the 1880s to successfully defend a document someone was trying to invalidate over an issue concerning a notary stamp. The stamp was clear enough to read, but had a slight smudge that the other side argued made it invalid. They were able to keep the document out in an administrative hearing and won the case on that level based on that. We appealed it to district court. My coworker found a case from the 1880s where the court described a notary stamp smudged in the same way and ruled it was valid. This was the only case she could find that addressed the issue. Based on that precedent, the district court overruled the administrative court and reversed its decision. It's quite common that a jury will convict a guy, but the conviction is overturned because the prosecution didn't present sufficient evidence of one of the elements of the offense. In an extremely rare version of this legal principle, my brother-in-law just had a case where the prosecution will forgot to present evidence proving the crime took place in the geographic jurisdiction, like county or state, of the court. Jurisdiction must be proven like any other element of a crime. The closest they got in the case was someone's testimony that it happened at home. Conviction reversed, defendant is free to go. I've cited a 19th century bestiality case from the Indiana Supreme Court as persuasive authority to an Illinois court. The defendant was convicted of having S with a chicken. The Indiana statute referred to unlawful union of man and beast. The defendant appealed, and his defense was that the dictionary definition of beast was a four-footed, cloven-hoofed animal. The Indiana Supreme Court affirmed the lower court with some beautiful language about statutory interpretation. The court was obligated to interpret the word as the Indiana legislature intended, and the court held that Indiana intended to outlaw S with animals as a whole rather than S with four-legged cloven-hoofed animals. I used this case backed with a string cite of more contemporary Illinois cases when OC's entire argument was based upon the definition of an undefined term in the statute. Thank you for watching. Guys, thank you for all the support and the likes. Subscribe to the channel if you're not subscribed yet. See you next time.